She built a $12 million company, then her partner stole it all. She signed away her future, except she never signed anything at all. Or so she thought. When the two of them started the company together, they were working out of a converted garage in the same neighborhood where they'd grown up. The co-founder had the vision, the CEO had the connections. For 3 years, that arrangement worked beautifully. By their 4th year of operation, the software platform they'd built together was valued at just over $12 million. Then, almost overnight, the co-founder found herself locked out of her own email, her equity diluted to nothing, and her name removed from every document that had ever tied her to the company she helped create. The explanation she received was a single sentence in a certified letter. Per the terms of the buyout agreement dated March 14th, your shares have been fully redeemed. The problem, she told her attorney, was that she had never signed any buyout agreement. Not on March 14th, not ever. She filed suit in civil court the following spring, seeking $4.7 million, representing her 40% stake in the company at the time of the alleged agreement. Her claim was straightforward and devastating. The signature on that document was a forgery, and the CEO had used it to push her out of a company worth more than either of them had ever dreamed it would become. Her legal team brought in a forensic document examiner who had testified in over 200 cases. His conclusion was methodical and damning. The pen pressure was inconsistent with her known signatures. The loop formation on the capital letters diverged from her established writing patterns. In his professional opinion, the signature on the March 14th agreement had not been produced by the plaintiff. The courtroom was quiet when he finished. Her attorney let the silence sit. But the CEO did not arrive without ammunition of his own. His defense was not that the signature was real. His defense was something far more complicated. He acknowledged through his attorney that the signature on that specific document was not produced by the co-founder in the traditional sense. What his team argued instead was that the co-founder had, on multiple occasions, explicitly authorized his assistant to sign on her behalf during a period when she was managing a serious family illness. They produced a series of text messages, 12 in total, spanning a 6-week window in late winter, in which the co-founder appeared to instruct the assistant to handle paperwork while she was away. His attorney read one message aloud. "Just have Sarah handle whatever comes through. I trust you both completely. I need to be here right now." His position was that the buyout agreement had been presented, reviewed, and signed by proxy, not forged, but executed under a standing and documented informal authorization. He argued this was a business dispute dressed up as a crime, and that the co-founder had simply experienced a change of heart after the company's value climbed. Both sides were credible. Both sides had evidence. And for 3 days, it was genuinely unclear which way this would fall. Then the assistant took the stand. She had worked for the CEO for 6 years. She was calm, professional, and precise. When asked whether the co-founder had verbally or in writing authorized her to sign the buyout agreement specifically, the assistant paused. Then she said no. She clarified that the general authorization the co-founder had provided was intended for routine correspondence, invoicing approvals, and minor vendor agreements. She stated that when the buyout document arrived, she had raised a concern to the CEO directly. She had asked whether this was something the co-founder should sign herself, given the magnitude of it. According to the assistant's testimony, the CEO told her, "She already knows about it, just get it done." She had trusted him, she had signed, and she had regretted it ever since. The judge ruled in favor of the co-founder. The proxy authorization argument collapsed the moment it became clear the CEO had knowingly directed the execution of a material agreement without the co-founder's specific informed consent. The court awarded her $3.1 million, less than she sought, adjusted for a separate equity agreement she had signed the prior year reducing her stake. But a substantial finding of liability nonetheless. The CEO was referred to the State Bar's Civil Fraud Division for further review. The company was sold 8 months later for $19 million. The co-founder received nothing from that transaction. The damages she was awarded had already been paid, and the court found no grounds to reopen the judgment. The assistant, who had been the one to finally tell the truth, was not employed by the time the case concluded. The co-founder got her money. The CEO faced consequences. The assistant lost her job for doing the right thing. So here's the question worth sitting with. If you were the one who signed something you knew wasn't right, because someone you trusted told you it was fine, how long would you have stayed quiet?